Good afternoon, everyone, and welcome to this week's afternoon program. The South African Bar Association hosts a speaker on a weekly basis to deal with a legal topic intended to assist young practitioners with training and development, and in so doing, to improve the quality of legal practitioners in our courts. This is a core value for us. Initially, the plan was to hold Acting Deputy Judge President Victor, who has unfortunately become unavailable. Thankfully, and at short notice, it is an honor and privilege to host Judge Keithley on Judge Victor's behalf, whom all of us are familiar with, and as a no-nonsense judge. Judge Keithley shall be addressing us on the topic titled Case Management and the application of the GLD practice manual in the COVID-19 landscape. A few housekeeping matters. These sessions are recorded and we appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. During the address, all participants shall accordingly automatically be muted. During the question and answer sessions, please restrict questions to the judge relevant to the topic under discussion. Participants can raise their hands, and when called upon to ask their question, you can simply unmute yourself and raise your question, and immediately thereafter, please mute your microphone. To do the official welcome of Judge Keithley, I now hand you over to Advocate Nicole Myatt. Over to you, Nicole. We're battling to hear you, Nicole. Nicole? Judge, as you were speaking about technology, Judge, I think your mic is muted.
There we go. Thank you. That's what
we had a discussion earlier about technology.
I know. I'm sorry Nicole isn't there because Nicole and I go back away. She took over my chambers when I went to the bench. So anyway.
It was indeed to do the welcome. I just don't Nicole,
yeah.
Nicole? There you go. Over to you, Nicole.
Can you hear me?
We can hear you perfectly. Here, Nicole.
Do I start at the beginning? Hi, Ahmed?
Yes.
Can I start?
Yes.
Okay. Thank you.
So, Nicole, we unfortunately we can't seem to hear you.
Maybe try switching off your camera. It might make the.
Okay. I think what we'll do, Nicole, is Judge Keithley, if perhaps myself and you we switch off our cameras and then have Nicole on for the interim. Okay, Nicole, now you can simply just switch on your camera.
So switch on my camera now.
Brilliant.
Okay.
We can hear you.
Okay. Can you hear me? Can I start?
Right. Perfect.
In the local division, before her elevation to the bench, Judge Keithley ran a successful practice at the Johannesburg Bar and sat in these very chambers which you see behind me. In line with her varied practice, Judge Keithley has presided over and written judgments on various aspects of the law. The systematic and practical nature of her is powerfully expressed in her judgments. Judge Keithley is known for her feisty nature and her no-nonsense approach. There is no better guide on how to navigate the case management and the application of the GLD practice manual terrain than in the incredible hands of Judge Keithley. Thank you.
Thank you so much, Nicole. Over to you, Judge Keithley. Judge, your mic is mic.
Okay, thank you. I'm glad I'm only feisty and no nonsense. I suspect counsel have called me much worse. and no doubt I've often deserved much worse. But thank you for those very kind words, Nicole. And good afternoon, everybody. It's my absolute pleasure to speak to you today. I know Judge Victor was supposed to do it, and unfortunately, as the acting Deputy Judge President, her presence was required elsewhere. So she asked me if I wouldn't mind filling in for her, which was more than happy to do. It's always lovely to get to talk to practitioners firsthand and to share with practitioners common matters of common interest between the bench and the bar. So thank you very much for having me here instead of Judge Victor. I've done a slide presentation, partly to assist people following, but also to assist me following, and I thought it might be of some use to you when you have gone away from here. It might be a bit of a touch point for you to return to. The topic I've been asked to discuss is perhaps I don't know if it was meant to be or not, but it comes at a very good time for me to discuss this topic, not so much because of the COVID angle. I think by now we've all got used to what COVID has meant for practice and for judging. And I think certainly in the two seats of our division, as practitioners and judges, we've managed to surmount the hurdle of COVID quite successfully. Me and most of my colleagues feel that we are busier than ever in COVID times, even though we're dealing with most matters online. And I'm pretty sure that many of you feel the same way. But the reason this topic is quite important from a practice point of view is that there have been recent changes to our practice manual through a practice directive, which really changes quite substantially the way in which the judicial case management system that we probably all just got used to, how that's going to run in the future and as it's running now at the moment. So from that point of view, I think it was quite a useful time to have this discussion, and I hope it can be of some practical value to everybody who's tuned in. Could I have the next slide, please? Slide number 2.
I'm sharing that now with. Just bear with me, Judge. Thank you.
Tell me when it's up.
I'll do that. Okay, Judge, it's up.
Unfortunately, it's a big picture of me up. I don't think it's my slide presentation that's up. Ahmed?
Judge, sorry, just bear with me. Sorry for 1 second. Just bear with me. Technology is really not on our side today. Just bear with me.
There we go. Excellent. Thank you. Okay. So you probably all are aware of it, but it might not have crossed your minds that there are, in fact, three different ways in which our practice and procedure in Johannesburg and Gauteng permits for judicial case management. The first is the ad hoc. I've called it ad hoc case management. So that's where you have, it's under our 2018, the practice manual, which I'll just refer to as the practice manual. And if we read that with Rule 37.8, which provides that parties may approach a judge, or the judge may call the parties in to consult and so on. And in our division, we have used that process for many, many years. And in terms of that process, any parties may approach the Deputy Judge President and request that a matter be sent off for judicial case management. There's no limitation on what kind of matter it can be. Generally speaking, it's usually matters that are quite complex or that can't move along, where the parties are at loggerheads. Frequently, we are asked to case manage divorce matters, but they can equally be commercial matters. So there's no limitation. It can be applications, it can be trials. A judge is allocated, they meet with the parties for however long it takes. They try to identify issues for determination. They try to narrow issues. They deal with, the judge would, together with the parties, deal with any interlocutory issues that might arise. And then at the end of that process, the judge will write to the Deputy Judge President and say, all right, this matter is now ripe for hearing. And once the Deputy Judge President gets that okay from the case management judge, then a trial date or an application date will be given to the parties. And normally with the ad hoc case management, a different judge will be allocated to hear the matter. So you may or may not have been involved in ad hoc case management. It's generally where the parties feel that the intervention of a judge to guide them along would be useful in ensuring that the matter eventually gets to court. And it's discretionary in the hands of the Deputy Judge President. Next slide, please. So that was the first type, and I'm not going to say anything more about that, but you're very welcome to ask any questions you wish to. The next is the next form of case management is under our Commercial Court Practice Directive, which was issued in October last year, and this particularly refers to commercial court matters. It's rather a unique procedure. I think we are the only division in the country that has a commercial court with this sort of procedure to follow. What happens here is that under the Commercial Court Practice Directives, a party or parties may apply to the Deputy Judge President for the matter to be certified as a commercial court matter. The Practice Directive does give some indication of the types of matters that will be or may be certified. Once it's certified as a commercial court matter, the Deputy Judge President will then allocate a particular judge to deal with it. It's similar to ad hoc case management in that the allocated judge then takes the matter forward with the parties and deals with the matter from then onwards. But what's different there are a number of things that are different with commercial court matters. The one is that the allocated judge would normally also hear the matter when it's eventually ripe for hearing, unless there are reasons not to. But the default position is that the judge who's been allocated to deal with the case management will hear the matter once it's ripe to do so. And then the other very important thing and difference between this and the other forms of all other forms of judicial case management is that with commercial court case management matters, a whole different procedure is set up in the Practice Directive. The process that is followed is modeled along the lines of arbitration proceedings. So witness statements, well, first of all, a statement of case is made out, which will include the relevant documents being attached to that. At a later stage, witness statements are filed, and the whole idea is to move these cases along fairly rapidly through the system. The judge very much directs what is to happen, when it is to happen. The judge is required to set very tight time frames to ensure the matter is dealt with as soon as possible. So those are particularly commercial court matters, often where they are complex and where it is felt that a judge getting involved as a case management officer will assist with the matter moving along. Next slide, please. That's number 4, I think. Oh, yes. Okay, so The third one is the one we'll spend a bit more time on, and this is the kind of judicial case management that I think most of you would be familiar with, and that is case management in civil trials. In our practice manual as it stands at present, and in fact it still does in the practice directive I'm going to refer to shortly, we are most concerned with why matters. Those of you who are familiar with this area of practice, I know Nicole Myatt is. So the why matters are road accident fund matters, PRASA matters, that's generally personal injury from passengers falling off trains. And then the third type is the MEC for health, provincial MEC for health. And those are most often cerebral palsy birth cases, but they could equally be botched operations and so on and so forth. Those three types of matters are all called why matters. Under our existing practice manual, they're dealt with under chapter 615. And those of you who've been in certification court will know about 615, and the no-nonsense judges like me will have drawn your attention to it, and so on and so forth, and you'll know what you have to do to get a certification.
Oh, sorry. All right, sorry.
That's, no, please go back. Yeah. So as the practice manual stands at present, it's those matters as well as any other civil trial in which expert evidence is to be led. That's goes under chapter 615. What has happened recently, though, is that in June 2021, the judge president, in fact, there was one earlier, I think in February of this year, and there's been a revised one in June 2021, where our judge president issued his revised directive, which deals with civil trial matters and case management and the bringing to trial of civil trial matters. The most important thing to understand, and those of you who aren't aware of this yet, you must please take note, is that the provisions of the new practice directive override chapter 6 of the practice manual. So it supplements what is existing in chapter 6 of the practice manual. And what it tries to do is to streamline further civil trials, and it does so not only, but with a large emphasis on what happens to those RAF, MEC and PRASA matters. The truth of the matter is most of these matters are RAF matters. And so we're really talking about RAF matters, but insofar as you have matters that involve passengers falling off trains or medical negligence matters against public hospitals, they are also affected. I might also add that all civil trials are affected by the new practice directive, and in certain instances it's made it a lot easier for civil trials. Next slide, please. Okay, before we get on to looking at the civil trial case management, I thought I'd better say something about COVID specific directives, because that was in the heading. You're probably aware of the fact that various practice directives have been issued during 2020 to deal with the management of court operations during COVID. The latest ones that I could pick up were 18th of September 2020, and you all know probably what these are about. All process is now filed on case lines. We've had to get used to that electronic system. And I have to say, were it not for case lines, I'm not sure that our 2 seats of this division could have functioned like we have. I know we all get frustrated with case lines, but it really has made it completely possible to continue to run our courts, even in the very hardest of lockdowns. The default position when we're still in this under the disaster management regulations is that appeals and motions will be conducted online. Civil matters can be conducted online. That should still be the default, although parties obviously can give their input to the judge and can ask the judge that they would prefer that evidence be led in person in court. In those cases, the judge still has a discretion to say, I don't think it would be safe. And what the judge then has, and the parties have a number of options open to them. The one would be for the judge to come into court. I certainly wouldn't think of doing so at present myself personally, with the Delta virus as rampant as it is at the moment. But there are other ways of doing it. One can have the judge sitting at home and the parties in open court. I dealt with an urgent matter a couple of weeks ago where we did exactly that. The parties came into court, but I sat at home and I was on the video screen. Parties can also run it from different offices themselves. I've had that system before where let's say the plaintiff is in an office and they call their witnesses, the respondent sits in another office across town even, they call their witnesses, and then I will always ask the parties to agree on a protocol. So they must agree on whether they can have somebody sitting in while evidence is being led to ensure that there's nobody who's feeding questions and so on and so forth. So various methods are available, and all of that is left, it's pragmatic. It really is pragmatic, and if really necessary, the court will be held in open, the matter will be heard in open court, but that's very much the default. Criminal trials all still happen in open court, and I think we have to thank those of our colleagues who have really been troopers in the trenches of criminal court. They've gone in unceasingly, put their health online to ensure that our criminal trial role does not get too far behind. And those of you who are in this area and have represented people in criminal court, you know, we owe you a debt of gratitude for that as well. So we've managed, I think, and I think this is something we can use in the future, that COVID has really given us a way of making our court processes a lot more flexible. Case managements with counsel, it's so easy to have them. You know, you now just link on with Zoom, and you can do it over lunch, you can do it early in the morning, and I'm afraid one can do it after hours, because it's possible. We've got used to it, we can do it. It does mean our work days have become very long, but I think we've become quite efficient, and the COVID protocols have forced us into that. Could I have the next slide, please? I then want to go back into looking at this whole judicial case management and certification process. I want to look first briefly at what it was like under the practice manual, and now the changes that have been introduced under the June 2021 practice directive. In fact, starting from February 2021, but I'm just going to call it the 2021 practice directive. Those of you who've been in trial certification court will know that under the practice manual, all civil trials in which expert evidence is to be led were required to follow the judicial case management or certification process that was outlined in chapter 6.15. And of course, what that meant was no later than 5 weeks before a trial date, the plaintiff would apply for a certification or judicial case management meeting date. They would have to get themselves ready, both parties. There'd have to be a pre-trial, they'd have to fill in that form, and they'd have to appear on the day, both parties, along with all sorts of other people, they'd appear on the day. And the whole purpose of the certification process was really to ensure that judges, it was aimed at helping judges to assess and case readiness, trial readiness rather, of the matter. And the idea was to try to ensure that only trial-ready cases got onto the trial roll. So even if you'd got a trial date before, you couldn't take that date up unless you had had a certification signed off from the judge to say this matter is trial ready. So you'll know there had to be pre-trial minutes filed, all the expert reports had to be filed, common cause issues to be identified, those that issues in dispute, and then the certifying judge, if they certified it ready, she would say the matter is certified ready for damages in respect of the following issues, and we're supposed to list the issues that were actually in dispute. As you all know, the system was relatively less than successful in cutting down on the trial roll, because invariably matters, the question would be, you know, if your expert affidavits are filed, then we're going to certify trial ready, and it would be certified ready for trial on quantum, full stop. So, you know, it didn't really help to narrow the issues and try. The other point about this judicial case management was and remains that you should try and get the parties to settle if possible, which would mean you take the burden off the trial roll rather than having matters still on the trial roll, and then at roll call, parties stand up and say, no, we're talking. So I think we were, you know, everyone was agreed this was a less than perfect solution or system to deal with the problem. I just want to make a bookmark there that the judicial case management model still remains in place, but for a very much more limited category of Y cases under the new practice directive. So it still has a role to play, but whereas under the practice manual, all matters involving expert evidence had to go through this process, that is now no longer the case. And you'll see that the certification court and judicial case management is now only limited to a small category of Y matters. So if we move on to the next slide, I want to just, before we look at what the changes are, let's look at what what problems the practice directive was trying to solve. I've already mentioned the fact that the civil trial has for many years been overburdened. Before we introduced the new practice directive system, at roll call there were up to 120 matters per day enrolled for trial. And I have that from the mouth of the Deputy Judge President himself, who I spoke to today, and he's done all the sums. He's got all the stats available. So you can imagine 120 cases a day, and you had 5 or so judges to deal with those matters. But what was even more problematic is that of all those enrolled matters, even though they'd been certified, many of them were still not ready for trial, even though they'd been certified. Some would be standing down, would ask to stand down for settlement because, you know, one of the characteristics of trial lawyers, unfortunately, is that, you know, one only really thinks, or your client only really thinks of settlement when you're at the door of the court. And so, you know, only at roll call do the parties really get together and try and settle something. So many of them would stand down for settlement. Others, there would be, you know, they'd been certified on the basis that the outstanding reports would be filed by X date, and those outstanding reports wouldn't be filed, and then there'd be applications to postpone, and so on and so forth. So in other words, the problem really was that the efforts that had been made before by introducing judicial case management under Chapter 615 had not really solved the problem. We were still getting an overburdening of the civil trial roll with RAF matters, but that's not the problem. The problem is it is with matters that were not trial ready or were never ever going to get to trial. I mean, that's the other. Many of these matters certified as trial ready were never going to get to trial because the settlement was going to happen sooner than later. And while the whole point of the case management system was to try to force a settlement earlier, which is why there were, rulings from the DJP at roll call to say, if you're standing it down for settlement, then you can't claim trial costs for the day. And practitioners getting very upset about that. But all of that was designed to force a settlement earlier in the proceedings so that the trial roll was not overwhelmed, and so that the deputy judge president and the officers of the court who have to then allocate judges were supposed to be getting a more realistic picture of how many actual trials would run. And quite clearly, the previous attempts to do that through the judicial case management / certification system really wasn't working. One of the real downsides of the problem was the long lead-in time for civil trial dates. At some stage it was over 15 months, and I'm pretty sure that at other stages it was even longer than 15 months. You would wait forever to get a trial date. And that was because the trial roll was filled up, for so long, because all these non-trial trials were taking up the trial date. So that was a real issue. And I think that's where the courts and practitioners really share common ground on this one. Any system that can streamline the process and can give you a trial date earlier must be a good thing for plaintiffs, defendants, practitioners, and courts alike. And then the other factor that cropped up was, of course, when the RAF changed its policy and when it withdrew briefs from attorneys. And suddenly we had a system where a trial date was allocated, the plaintiff would arrive, and there was just nobody from the RAF there. The attorneys had filed their notices of withdrawal, as they were entitled to do. So all the certification that had gone on before just reached an absolute dead end. So it was a whole combination of all of those reasons which forced a rethink. And that rethink took place much earlier this year. And it culminated, next slide, in, if we could have the next slide, please. It culminated in the June, 1st of February, and then now the June. It's just been slightly, there were a few amendments that had to be made for clarity and so on, which is why there was a revision in June. So let's look at what the case management process is. And you will see that, in fact, judicial case management now plays, in civil trials, plays a very much lesser role than it did. And you will see that that's still for the same purpose, which is to streamline the process. So we've now adopted a different strategy, which isn't to increase, funnily enough, judicial case management, but rather to decrease the role of judicial case management. The reason for the changes has been to ensure that only trial-ready Y matters are enrolled for trial, and only Y matters that are ready will be allocated. Only they will be given a date, and if they're not trial-ready, they will not be given a date. And you will see that what the model does, it employs a system of different routes for plaintiff to follow. They're not optional routes. The practice directive tells you what those routes are, but depending on the nature of your case and on whether the defendant is actually involved and remains involved, you'll follow a different route. One of those routes is case management. But it's not the only route, which was the previous model. One very big change is that, and I've hinted at this before, is that only Y matters are now subject to judicial case management. So all of the other civil trial matters where expert evidence is going to be led, they don't need to be case managed anymore. It's only the Y matters, the RAF, MEC and PRASA matters, and it's only those Y matters where both parties remain actively engaged in the matter up to the pre-trial minutes, literally, stage. So, and final pre-trial minutes, not even only if they're both still engaged when the matter is ripe for trial, will the matter then be subject to judicial case management. Next slide, please. Yeah, okay, so I cannot, those of you who have looked at the practice directive will see that it's an incredibly dense document and it's not that easy to understand. So, which is one of the reasons I gave you a written presentation, because I thought you might use it to try and simplify your way through the practice directive. I'm not even going to begin to try and explain to you the ins and outs of when you must do what and how and when and whatever. I'm really going to give you just a broad overview of how the system works. So let's look first at where case management, judicial case management or certification is still required. There you will look at Chapter 5 and you will see this is the 2021 Practice Directive, and you will see that Chapter 5 says specifically the underlying principle that governs the judicial case management regime is that the procedure only applies to matters in which the parties have engaged each other thus far regarding the prerequisite pre-trial procedures. A matter in which only one party has been active in this regard shall be dealt with in terms of Chapter 6 below. And I might also add, it doesn't come out there, but I might also add that if you read the practice directive, when they say only matters in which parties have engaged, they're referring specifically to the Y matters. The non-Y matters are dealt with under 7. So it is only RAF, PRASA, MEC matters in which the parties remain engaged up to the time when it's ready for set down, basically, that have to undergo the judicial case management process. And you'll find the appropriate procedure in Chapter 4 of the practice directive. You'll see that it more or less mirrors Chapter 615. It's more or less the same thing as Chapter 615. But remember, it will now only be those matters where both parties have remained actively involved. So in other words, all pleadings have been filed, all expert reports have been filed, discovery is completed, pre-trial minutes are all up to date, and where the attorneys haven't withdrawn for the defendant, and the parties are now ready to actually go to trial. In those matters, you'll go to the judicial case management, you'll apply to the registrar for a date, you'll go to judicial case management for certification, and you'll follow more or less the same process as before. I haven't sat in judicial, I think I sat in judicial case management or certification court much earlier on this year when this directive had just come into play, and there were very few matters that were being referred to certification court, because it really is only a small number. So most of your MEC matters will still be getting, will still have to undergo case management. I'm not so sure about the PRASA. Generally speaking, I think those are generally defended. They probably will still undergo case management. But the vast majority of the RAF matters in practice are no longer going to go this route. And that's simply because the RAF's change in policy has meant that they aren't instructing attorneys. So most RAF matters will no longer be going the judicial case management route. It doesn't mean that they've been forgotten about. We're going to do that next. But if you have any other matters that in the old days would have involved expert evidence, and therefore you would have thought that you've got to advise your client, you've got to apply for a certification. Remember, you don't any longer have to do so, which I think is quite a relief for practitioners involved. You know, sometimes there are damages claims in a ordinary delictual matter involving damage to property where you need expert evidence. Those don't any longer need to go for judicial case management. And I'll deal with that. That's under Chapter 7. So remember that the case management remains in place. It's more or less the same process, but it's only for those PRASA, RAF, MEC matters where there is an active trial waiting in the wings, where both parties are engaged. Next slide, please. What about those vast majority, certainly of RAF matters, where there's still litigation, but the RAF in particular is sort of missing in action? What the new directive says is that those matters get diverted down a different river. They're no longer case managed. So what happens with those matters, and here we're talking about, I think there are about 4 categories where let's say that the RAF has filed a notice of intention to defend, where they haven't filed a notice of intention to defend, or they haven't filed a plea. Those would be normally default, and now there's a special route for default. So that's the one category. The other one is where they did so, they filed a plea, but they have become recalcitrant when it comes to all the pre-trial processes that need to be followed. So, for example, the attorney for the plaintiff has written 5 times to say, please, here are some dates, we need to hold a pre-trial conference, please can you tell us when you're available, and the letter is just ignored. Or there's a request for further particulars and it's just ignored and you can't raise them. Or discovery, they just haven't discovered. And you can get no joy. In other words, they're no longer being compliant with their duties as defendants. And then you get another category where that everyone might have done discovery and so on, because all that was done while attorneys were still on brief for the RAF, but suddenly in the meantime their brief has been pulled, and what do you do now? Because how do you keep the matter going? Previously you would have had to go to certification court and the court would have said ready for trial and you'd have been on the trial roll. Well, that's not the way we do it anymore. In all of those matters, plaintiffs have to use the trial interlocutory court. It's not exactly the same trial interlocutory court as before. This trial interlocutory court sits every day of the week, Monday to Thursday, throughout recess. The only time it doesn't sit is, I think, the period between Christmas and New Year. Apart from that, those 2 weeks, apart from that, it sits every week of the year, and it's specifically aimed at giving compulsion orders against plaintiffs in Y matters where they have failed to comply with any of their pre-trial obligations, haven't made further or better discovery, so all of those matters where one of your remedies, of course, is to have the defense struck. And these are all matters that go to the trial interlocutory court. You set the matter down. The judge will first issue a compulsion order, and if they fail to comply with that compulsion order, the judge will then go back to the court and you will apply for an order where the judge says you now may approach that the defense is struck, and you may approach the registrar to obtain a default judgment date. So that, and when the registrar processes those and gives a date, he or she has actually got to make it a DJ file, so that when it comes to roll call and so on, the deputy judge president knows that this is a default, and it will go to a judge by way of default. And then there are specific, the practice, sorry, I've just gone completely blank. Plaintiff for the counsel for the plaintiff has to file quite an extensive practice note, which is set out in order to assist the judge to make a proper determination on things like quantum and so on. So that's what you do in cases where the party has just fallen by. So in most cases it's the RAF where they're just no longer playing along. It does sometimes happen that the RAF, they must be filed with a set down date, and sometimes they do rock up, but 9 times out of 10, by the time it gets to that stage, 2 things happen. The one is that the parties then talk settlement when it's going for default judgment, or the matter proceeds on a completely default judgment basis, and then it's an issue between the court, the judge concerned, and counsel for the plaintiff, and the judge must be concerned that the relief that is being asked for by default is consistent with the averments that are made, the evidence, and so on. So those cases where either there was never a notice of intention to defend or a plea, there you don't have to apply for a compulsion order, but you go to the trial interlocutory because there's nothing to compel. You apply to the trial interlocutory court straight away and you say, please, could I have an order directing that the registrar give a date for default judgment in this matter? Whereas in others where the defendant has been recalcitrant and failed to comply, you go to trial interlocutory, you get your compliance order, and when that isn't complied with, you then go the default judgment route. But that river, you can see how the river that goes around judicial case management, although there are a few more procedural steps in the way, and I can understand that practitioners are going to have to get used to that, but it's a much more straightforward path actually to get your default judgment at the end of the day. And it also relieves the burden of the trial court when, you know, the trial court doesn't know how many cases are actually going to run, and so on. One thing that I've mentioned before, and I must mention it again, that on any of these routes, if the matter becomes settled, it must be removed from the trial roll. It must be removed from the default judgment court as well. And it then goes to the settlement court. So the settlement court is also there to ensure that where matters become settled, either before a default judgment date or on default judgment date, the settlement court is then tasked with granting the order or not. Don't go to the judge who's thinks they're in a default judgment matter, and then the parties come to the judge and say, we settled, can you give us a settlement order? Hopefully, all judges will say to you, no, the practice directive says it must go to settlement court. So that's the other thing just to bear in mind there. Just something else. In the default judgment court, one other something else that has been put in place is that experts may give confirmatory affidavits, and that's commonly done. But bear in mind, you know, judges all have their own way of doing things. I'm known as the no-nonsense judge. Other judges might be known as those who just prefer to actually hear it out of the mouths of the experts themselves. And so you will get judges, and they're within their rights to do so, to say, I know they've given confirmatories, but I actually want you to specifically lead the evidence of so and so and so and so. It does place plaintiffs in a bit of a quandary sometimes. Do they book their expert for the day or not? It can be costly for the public purse because the RAF has to pay the money at the end of the day. What I would suggest you do there is try and contact the judge's registrar as soon as you know It's usually the day or so before you know who you're being allocated. Try and get hold of the registrar and ask if you can get an indication of whether you should book your experts or not. They won't always be able to give you a firm idea, but that's one way of trying to deal with that particular problem. Could I have the next slide? I think we're nearly at the end, you'll be pleased to know. And then, of course, we have all the other matters, which are your commercial matters where there's been a breach of a lease agreement or a commercial lease agreement, or damage was done, or you know, and those sorts of things. Contractual disputes, any number. Even if those are going to have expert evidence, there's no need for judicial case management or certification. Once you are all ready, you apply to the registrar to certify that it's ready for trial, not a judge. But be warned, the instructing attorney has to make an application to the registrar by making a statement. And in that statement, she has to say that she has personal knowledge that the practice directive has been complied with, that there are no interlocutories outstanding or expected, that a recent pre-trial minute must be attached. I think it's within 30 days, no longer than 30 days old. And she's also got to confirm that all documents have been uploaded on case lines in the prescribed format. And the practice directive also tells you, I think if you go to, it's part C, I think, of the case lines and how you must upload your documents and so on and so forth. So the attorney, you shouldn't apply for a date through the registrar for those non-Y civil trial matters unless all your eggs are properly, I was going to say, in the same basket. That's a mixed metaphor. Everything is right. Your ducks are in a row. You can say everything's fine, because if not, I'm afraid you can be reported to the GJP and you will forfeit your trial date. So if, for example, the judge gets there and sees that half the documents haven't been uploaded, that matter is not going to go ahead that day. And your client won't be very happy. So be very careful. Although it's a relatively simple matter to get a trial date from the registrar, and you don't have to do case management, you've got to make sure that you've complied with the practice directive. And then just the final slide, I just wanted to look if I could have the final one. You know, is the new system succeeding? It is very early. I'd be interested in your views on that. I think, and I sympathize with practitioners. We've changed course it wasn't a very long time ago that we had the whole case management process, and we've now changed course on that. And the new practice directive really isn't very simple to read or understand. I do hope I've been able to assist you a little bit in understanding what the model is about. But I'd be interested to hear what you say, whether you think it's can be successful or not. It's a bit early, but there are some encouraging indicators. The lead-in time for trials is now 3 months. And that really is because so many matters have been diverted from the trial role. There've been so many matters. If you think about it, you know, the default judgment matters will be allocated a default judgment date once the compulsions and so on are done and not complied with, and then you'll get your date. It's not as if everything's still up in the air when the matter comes to be allocated a date. In a default judgment matter, if you allocated a date, you know you can proceed on that date. So it's not a waste of court time. That matter is going to proceed. It's good that it's on it's good that it's on the trial, being allocated a trial date. But because we are no longer having case management and certification of all these cases that, even though they're certified, actually are not trial ready. And I've sat there as a judge and I know I'll certify this case ready because what can I do? The plaintiff's done everything that they can. I've got a certified, but I know it's not going to run on that trial date. So all of those matters are no longer going through a certification process and therefore are no longer getting trial dates. What it means then is that there's a far shorter lead-in time for trials to be allocated a trial. And that's because those are the trials generally that are going to run. The civil trial roll, I looked at some of the statistics that Judge Sutherland sent through to me, and I hope I'm reading them correctly, but it seems to be that they're now far less than 20 a day. 20 is quite high. Usually they're far less than 20 matters a day that are now on the civil trial roll rather. So that's a big win. It doesn't mean, and I want to make this point, it doesn't mean that judges are working less. We're still working hard on RAF matters. It's just that we're working in different courts. So instead of us working in trial certification court, and then, sitting around the whole week on RAF trials when, you are allocated matters that can't get anywhere or settle at the door of the court, we are getting matters in RAF court that are ready to roll, or that are in, that proceed by way of default, which can take a lot of time on the part of the judge and the counsel involved, and that's time well spent. Or we are sitting in trial interlocutory court, which is an incredibly busy court, and it throws up quite difficult issues sometimes. And then of course we are also now sitting in settlement court, which is also not an easy court to sit in. But at least our judicial time is being spent on matters that have actually reached finality, rather than on matters that are still hanging around in the air somewhat. So that's sort of the input of what I wanted to give. I see I've gone over time, and I'm terribly, terribly sorry about that. But I'm happy to sit. If people want to raise questions, I'm more than happy to sit longer.
Thank you so much for that exceptionally informative address.
Not the most exciting topic in the world, I'm the first one to say.
Judge Keithley, thank you so much. What I'm going to do now is I'm going to open up the question, and there's going to be a brief question and answer session.
That's fine. I'm more than happy.
If that's fine.
If people want to make comments, I'm just an ordinary judge, but I'll feed it through to the powers that be.
Thank you so much, Judge Keithley. Before the first question, I would like to raise, but before I get to that, I would like to raise a comment in that regard. And you have mentioned that you are known to be the no-nonsense judge. In light of your address, and further, I would attempt to rename you to be the most knowledgeable judge.
Oh, that's what a compliment.
Thank you so much.
Thank you.
Judge Keithley, my question is as follows. Many unrepresented members of society attend our courts. How can the courts ensure that the indigent and unrepresented members of society can access the online platforms for managing cases in compliance with the practice manual?
It's an excellent question, and I can answer that. The online system is difficult for everybody to get to grips with at first, but I have had any number of cases where there are self-represented and often indigent people who've managed to upload because they are assisted in the relevant offices downstairs. The case lines people and everybody else, and our registrars are very helpful. They help them, they assist them to upload, and I don't think any judge would refuse, even if it came to, our registrars having to deliver to us hard copies. None of us would refuse that. My experience has been that the system does work, and that people haven't been, if my registrar was here, he could confirm. We see all manner of ways in which things are uploaded onto case lines, and as long as it's there, we will look at it. And so in my experience, that hasn't been, the case lines itself hasn't, look, one doesn't know how many people fall through the cracks. But all I can say is that I have had any number of matters involving self-represented indigent people who have uploaded their documents through the assistance available to them at court, who've uploaded their documents, and they've all been available on case lines. I've never had a problem there. And can I say, if we did have a problem, we would bend over backwards to assist. We'd make sure of that. And then as far as the hearings go, I think that's another system that has worked really well. Those of you who go, tread the corridors and courtrooms of the Joburg High Court, you will know that there are always at least one or two courts that are set aside for people who want to appear in person. And we get people who are appearing in person in unopposed motion court when we deal with particularly unopposed evictions and a person, or foreclosures, and a person will come and want to be heard. And there's a set of rules. They go to the front door and they're told where to go, and it's court 9C or whatever the court might be that week or day. They go there, and there's always somebody there to assist them, help them log on, not even log on. They do it for them, and they sit and they are heard in court. We get that in, obviously, opposed motions as well, where we have that, and we get it obviously in urgent court. So that system has worked really, really well. I've held cases like that after hours, with people who are self-represented. I had a matter the night before Christmas Eve where there was a burial dispute, and that courtroom was open, and the respondent came to court late at night at about 9 o'clock, and she had her say in court, and we managed to resolve that matter. So, in a funny way, I think as long as the systems are there, you can use it. And in some ways it might, I don't know that it makes it easier or not for people, but certainly the fact that it's online doesn't mean that the physical fallback system isn't there. It's being used in a hybrid way. And unless you've heard things different, I haven't heard of any complaints, and I've had umpty number of self-represented people appearing in front of me throughout this COVID era with all their documents on case lines and appearing on screen with the assistance of court officials.
Thank you so much, Judge.
And it might be a way to, that might be a way. I must also say that going to the registrar and getting a brown file and stamping it also isn't very user-friendly either if you don't know your way, So I suppose the old system in a way was also a bit of a barrier. But yeah, anyway, I hope that answers your question.
Indeed it does. Thank you so much, Judge. Judge, there's a question from Mpo Patamani, rather. Sorry, Mpo, you could just kindly unmute your mic and video.
Thank you.
Judge.
Good evening, Judge.
Hello, Mpo.
How are you, Judge?
Good, thank you.
Judge, my question is regarding, I think it's section 37, number 37 of the directives with regards to stamped interlocutory court orders.
Is that the practice manual, or is it the recent directive?
The recent directive, my lady.
Recent directive, okay.
Yes.
I'm just calling it up so I know what, you won't see it on your screen, but I just want to call it up. So is it, and you say paragraph 37? Paragraph 37. I don't know why this is, oh, hang on, I've got the wrong thing, that's why. Hold on one sec. 37. Okay, failure by the plaintiff to comply will result in the lapsing of the trial. Yeah, is that the one?
Yes, that's the one.
Yes.
Judge, with regards to that, we are required to upload a TIC court order that has been stamped by the registrar before we can obviously proceed on trial date. These matters have previously been given these trial dates, so a lot of attorneys are trying to squash in the interlocutory court dates before the trial dates.
Yes.
So the uploading, there's a bit of a lag between getting the order and it being the stamped one being uploaded onto case lines.
I understand that. Yeah,
Yes.
yeah, that's a perennial. I understand it's a perennial problem that the poor JP and DJPs have to try, tear their hair out about. So you're actually talking about the official court order that then gets the court stamp and then gets uploaded.
Indeed so.
And so you get your order and say 3 weeks later it's still not uploaded. Is that the problem?
That's the problem. And then you appear for allocation and you're unable to get allocation because
you haven't got that.
Yes, and the registrar doesn't finally enroll the matter because there isn't a stamped court order.
Okay.
On case lines.
I see that there is, and I'm reading it as we speak. I see that there are standard operating procedures regarding the expeditious processing and publication of court orders. Those were issued on the 19th of July. It's not to the general public, so it's obviously internal, but it talks about frequent occasions where court orders granted in unopposed motion court and other courts have not been published timeously. Delays are an embarrassment to the court administration, as it constitutes a failure to honor a failure to honor our undertakings to the profession, etc., etc. It seems to be that the judge president has issued internally standard operating procedures. So that all I can say is because I'm not the judge president or the deputy judge president, I don't know what the answer is, but I think that it is a problem that has been identified, and that the judge president is trying to deal with it. And from what you're saying, it's an ongoing problem. Is that correct?
That's correct, Judge.
Yeah, and that is happening. So you are ready. You get what's the time lag at the moment?
I'm not quite sure what the time lag is, but I know for a fact that when appearing on date of allocation, the allocated date, when appearing for allocation, we're unable to get allocated because we are not appearing on the rolls for the day because the registrar has not
given
not.
And this is in what sort of matters is this?
RAF matters.
Oh, in RAF matters.
Some Minister of Police matters as well.
Okay. So what you are wanting is, what do you want? Oh, so it's the compulsion orders that haven't been.
Yes.
The compelling orders. Okay. But why has the registrar then given you a date?
No, from previous dates.
Oh, I see. So you already had a date.
Yes. Paragraph 6 applies to matters where there's already dates previously allocated, where the defendant attorney has withdrawn, and where
and you've got your compelling orders.
You've got your compelling order, but the stamped one has not been uploaded by the judge's clerk. So when it comes to final enrollment, the court registrar will not finally enroll the matter without the
stamped one
being uploaded on case lines. And we can't upload it ourselves because it's still with the registrar. The stamped one is still with the registrar.
I will give the JP a call and talk to him specifically about this issue.
Thank you, Judge.
Okay. It does seem to me that if there's because what's always uploaded is the the draft that is made an order of court. It's then uploaded, but it hasn't been typed and stamped. And you're saying the registrar is insisting on that?
That's correct.
Yeah. Okay.
Okay. Thank you, Judge.
I can't answer you, but I can note the problem and I can hear what the JP says. And, may I also say that I know that our JP is very open to, his ear is always open to the profession and our DJP, and our acting DJP at the moment. So if these sorts of issues are still happening, then I would suggest that it won't be just a matter affecting your organization, it will be the LPC. Well, you all fall under, I suppose, the LPC, and it might be that one could just get a little delegation together and try and talk to the JP about this issue. But I will raise that with him. And as I understand it, it's that the registrar is insisting on the stamped and retyped, even though you've got a date from long ago.
That's correct, Judge.
Yeah.
And so because the TIC certificate has not, the TIC order has not been uploaded,
Yes.
they don't finally enroll the matter, then we don't appear on the roll for the day.
Yes. Yeah. So you'd get a date then probably in 3 months' time, rather.
That's true.
Yeah. And these are cases where you say you got so these would be probably where you were certified much earlier this year.
From last year.
Yeah, exactly. So it's that category, hey? It's that category of, so where dates were given,
Before.
Yeah. So it's that specific. Of course, now it wouldn't be an issue because you'd only get the registrar would give you a date. You'd then apply and so on. But so I understand it's from when dates were given before.
Okay.
Look, I think we always also knew that there would be that interim category of cases where, there couldn't be a clean break between two categories of cases.
That's correct, Judge. These are all the matters that would fall under the transitional arrangement.
Exactly, yeah. So it's the transitional matters, yeah. And what is your other sense of how the system works, if I can add?
I'm actually happy with the system. I find it very ideal. It's easier to work with. We always have access to all the papers. It's been a very nice system. I personally like the system.
Yeah, I suppose it's always personal. Thank you very much, Paul. I will certainly see what I can find out about that. Hey,
thank you.
And your surname was? Thank you. Thank you, Paul.
Thank you, Judge.
Yes.
Thank you so much, Judge. Judge, there's a question from Nicole Mayet.
Hello, Nicole.
Hello, Judge. Judge, my question is that in the case management, you're given directions and the practice manual makes a provision that if your opponent does not comply, you can then compel him and strike off the defense.
Yeah.
My question is it also contempt of court?
To fail to, well, I think it would be, but as we know, contempt can give rise to a number of different remedies. Were you thinking of running with the contempt of court?
We were debating whether or not we should also bring an application for contempt of court because most people are not really worried about the compel, but contempt would be a huge thing.
Yeah.
But is the director?
I mean, of course. Well, it's an order. It says you are to file by X date, and the court gives an order. You are to file by X date. The court order does say, if you don't, the applicant may apply for striking out, but that doesn't mean that the applicant, I think, has made only that election. Is your intention to try to wake the RAF up?
Oh, no, I don't do RAF anymore.
Okay. Well,
I've given up on them.
No. I mean, I just assumed that if anyone was in contempt, unfortunately, it would probably be the RAF. So this is in the just an ordinary matter where they haven't done. Yeah. No, I mean,
So we can elevate the.
I think there is a court order. You haven't complied with the order. There might be arguments where they say this is a sledgehammer, that because it's from the rules, isn't it? That if you don't comply with discovery, there's a rule. If you don't do this, you can have the defense struck. So that seems to be the go-to rule, is to have the defense struck. But I think strictly speaking, it's probably also contempt. I've never known of a contempt case we don't need you don't need contempt doesn't, it just means with intent and deliberately.
Oh, okay. Thank you, Judge.
To fail to, you knew about the order and you intended deliberately to ignore it. That would constitute contempt. So I don't see why it isn't contempt. I'm not sure what practical implications there might be from that, but yeah.
Thank you.
Okay. All right. Thank you, Nicole. Any other questions? There are a few hands up, I see.
Thank you, Judge. There's a question from Siyabonga Chungu. Siyabonga, you can simply unmute your mic in your video if you prefer.
Yes. If I can switch on my camera.
Of course, Siyabonga.
Yeah, okay. No, I am inside the CBC, but using Siyabonga's device because I thought that since I'm with CBC.
CBC. Thank you, CBC.
Yes.
Interrupt you, CBC. Okay, now we can.
Thank you for hosting us, Judge.
It was my pleasure.
I just have a quick question here. Why is it that some of your learned brothers and sisters who are judges want to decide matters purely on papers? I feel that is highly unfair because now as juniors, we need that exposure, even if we're no longer appearing in court physically, even if it's virtual. It helps us. But the other factor is that you find that you prepare yourself, and then since the matter is no longer proceeding, virtually, it deprives us of bread and butter issues in this regard, and I feel it is very unfair. Perhaps there should be a provision to say practitioners should motivate if they want their matters to be dealt with physically or virtually, because also I feel that somehow it has constitutional implications here in this regard. I'm just asking.
Could I ask, CBC, are you meaning that there's no oral hearing at all, or do you mean only a virtual?
No oral hearing at all. Matters just entertained on papers.
Okay, and how many times has that happened to you?
About 3 times.
Was it in appeals?
Not in appeals. It would be some of the unopposed matters.
Okay. Yeah. Well, sometimes the unopposed, it's if the matter is so open and closed, you don't really need, if they're going to grant you the order anyway, and you for the applicant, and they're going to grant the order, and there's no issue. I mean, they're saving everybody's time and expense. I don't know that that they have to take into account the fee that you would normally charge by going to court and saying, my lord, my lady, I submit the papers are all in order, and the court says, yes, they are, you can have your order. I can understand the constitutional implications in opposed matters, possibly. I don't think in application proceedings that there's any constitutional implication of hearing submissions virtually rather than in court. I don't think that's a constitutional issue. It might be that where you want to be heard and it's opposed and the matter is not heard, and the judge says, no, I don't need to hear anything. But our practice directive says that the practitioners themselves should give an indication in a practice note. In opposed matters, they should give an indication whether they forego an oral hearing and are happy for it to be decided on the papers. Certainly in opposed matters, I'm not aware. I've had a couple of matters decided on the paper, but that's where the parties have forgone the need. For both parties have said, we don't need you to hear us. We've made full heads of argument. Are you specifically talking about unopposed matters?
I'm talking about unopposed matters, especially where it has not been asked. Because even if a matter can be straightforward, it can be straightforward. Just think of someone who's a junior counsel who just came straight into practice here. Even if they were to get the little money that they would make just for confirming a draft order, I still believe that apart from the money, it gives them the feel, it exposes them. It gives them confidence and exposure to the court because you get to see other practitioners as well who are seeing us addressing.
Look, we all feel that. We all feeling, as judges, are not happy just sitting at home and not seeing our colleagues. You miss a lot of learning by not interacting with your peers, and that's COVID. I don't, my unopposed motion court, quite frankly, it's less work to just have everybody move their applications with me having read them than to try and work out which ones I'm not going to ask, and then my secretary has to say, Mr. So-and-so, the judge doesn't need you to appear tomorrow. Ms. So-and-so, the judge doesn't need. Generally speaking, I think most of us run our unopposed motions on you stand up and you move your application. If a counsel has specifically said, should the court require it, then I will be available. But I'm not sure that I certainly haven't ever had a case where counsel stands up and I say, I don't need to hear you and you can't charge your fee. Most of us just deal with it like we used to. But I take your point, and I think you are absolutely correct in the sense that we all hope this jolly virus, we get on top of it soon, because there's no question our children aren't learning because they're not in the normal school environment. Our young professionals like lawyers are not learning because they're not in the normal environment. And while we can be very efficient on using case lines and using virtual platforms, we're not getting the cross-pollination that we normally get. So I think you've got a very good point. And I'll make a point I will make a point. I'm not a judge that is big on saying you don't have to appear, you don't have to appear, but I'll give you a solemn promise from my side of this that I won't easily say to young counsel in an unopposed matter that they don't have to appear even if they want to. Although once you've appeared in front of me in unopposed motions, you might change your mind. And the next time you might want to say, oops, Judge Keithley, no, I don't want to appear. Because if your papers aren't in order or you don't know your papers, that's when I can be feisty. But I take your point.
Thank you very much, Judge.
And I wish you luck with your growing your new practice.
Thank you. I appreciate that.
Thank you so much, Judge. Judge, there's a question from Mohammed Patel. Mohammed Patel, you can simply unmute your mic and your video.
Judge?
Yes.
I must state from the beginning that I find it rather odd addressing you in the evening and being unrobed.
That's fine, Mr.
And I would like to thank you for taking the time out of your day and to address us. I think everyone that's been a part of this platform has found it rather informative.
Good.
Judge, my question is with regards to, well, it's more of an issue that we're having as junior practitioners. And I'm taking you up on your offer and maybe addressing it, if not you yourself, maybe addressing it to the powers that be. Judge, we're having an issue in both case management matters and the unopposed matters, in that some judges require us to appear in open court in both Pretoria and Johannesburg. Judge, the first question I have is that these open court hearings, is it solely at the discretion of the judge allocated for that matter? And as a second question, you mentioned in your presentation that case lines, look, it's working brilliantly, and I believe and I hope it's going to be here to stay.
No, listen, I didn't say it's working brilliantly. We all get very cross with it at times, but yeah.
Yes, and it's here to stay, and it's going to be here for a long while. But is there any plans, especially with regards to open court hearings now in the near future, to improve the infrastructure of the courts in terms of the Wi-Fi access and access to plug points for counsel? Because appearing in front of judges, access, I mean, in particularly the Pretoria and the Joburg High Courts, getting inside access within the court, it's very, very difficult with a modem, and Wi-Fi access would be of help to us, and even having plug points. I mean, at the moment, I mean, I think in the actual courtrooms, there's about 4 plug points that 30 or 40 practitioners have to be using at the same time. And I did have a third question, Judge, but I think you've addressed it earlier. Thank you so much, Judge.
Mr. Patel, I think the plug points issue, especially now with case lines, I'm sure that's something that could be taken up with our court manager or the office manager. If you got somebody, perhaps, the different bars just made an appointment, different, when I say the bars, that you've all got the same interest. I mean, why can't they just have a couple of long extensions with those multi-plug, just multi-plugs attached where you can do a whole lot. It doesn't seem to me like that would be a whole lot of money that would need to be spent. You'd have to watch out when you walked up and down the aisles and didn't break your neck, and there might be health and safety issues. I hadn't thought of that, but I think that's a fair point. When it comes to actually putting new plugs in walls, I think, we're just very grateful when a wall doesn't fall down. So I don't think we can hope for them to be actually putting in lots of plug points. But it strikes me there shouldn't be a reason not to supply a few of those long extensions with some big multi-plugs, especially in things like unopposed motion court, where you've got lots of practitioners. It's that court and possibly urgent court, possibly, but more unopposed motions and trial interlocutories and so on. I think I can also raise that with the JP. And I think that really should be something that practitioners' organizations, I'm sure, could approach the court manager about. It seems to be such a practical issue. But I will raise it with the JP. Doesn't seem to me to be and he's a big IT enthusiast. So, I'll raise that. And I'll also raise the transitional arrangements issue with the JP. As far as appearances in court, judges requiring open court appearances, I'm one of the judges who gets emails from the JP, and those emails say, please, everybody, please use online court unless it's absolutely essential that you should have open court. But because we're not employees, judges we are independent. And so it's very difficult for the JP to force judges not to go into open court. And I mean, I can't speak for those. I have not been into the court since the first lockdown of last year. And I have managed a full court roll, and I'm not alone. I can tell you on double hands how many of my colleagues have done exactly the same. But there are some judges, for whatever their own personal reasons are, and I think that it does present an issue. It presents an issue of health and safety. You may be living with elderly parents, and I don't. The one way you might try and deal with it is, if it crops up in the future, is possibly, and if you have a real reason not to, let's say you have an elderly relative at home or whatever it is, or you yourself have got underlying issues, is possibly to try and switch. If there are two, there are always two judges on motion court, try and switch to the other one. I mean, I know the JP can't force it. He's kind of done what he can. Yeah.
Judge, on that point, I was stuck between a rock and a hard place a few months ago, for this current lockdown, level 4, where I had about 3 or 4 matters on a particular day, and 2 matters were heard in person in open court, and the other 2 were heard virtually. So it ties in both of my questions about having it in open court in the infrastructure, because I was in Pretoria and I couldn't log on to actually do my other 2 matters.
Yeah, no, exactly. I see what you mean. Joburg's better with Wi-Fi, though, I think.
It is, but it depends where you are in the building.
Yeah, and it does depend where you are. But I think it's the criminal courts that might not be so good on the Wi-Fi. But generally on the upper levels, it is better. So the Wi-Fi, I think, is one thing, and we don't have to. But certainly the plug points, and I don't know what else to say. I will alert the JP to the open court issue again, and I will just say to him that this is unsolicited feedback I got, from practitioners, and you aren't alone. The science is there. The science is there. We shouldn't be. If there are other ways of dealing with court matters, we should deal with them. It's just, for me, it's a no-brainer. But, you know, I am aware that others of my colleagues, and I don't know who they are, I don't want to know who they are, and I don't know why, but they seem to prefer to go into court. I think the majority of us don't, though. I think the majority of us, you know, for our own health and safety, have done that. But for what it's worth, I will raise with the JP that there is a concern. There was a letter, I think, from the JSA not so long ago to the JP, asking the JP please to, you know, do something about this. So it's certainly you aren't alone. Yeah.
Thank you, Judge.
Pleasure.
Thank you so much, Judge. Judge Keithley, there are a number of other questions from participants. However, time does not permit for such, and regrettably, I have closed the question and answer session. Before I hand it over to Advocate Nicole to do the closing, on a lighter note, you mentioned that the JP is an IT expert. Could I personally request that you request the JP to assist Advocate Nicole with her internet connection? She missed a most important aspect of Advocate Nicole's pleasant when welcoming address.
I will do that. I'm sure the JP would love to assist Advocate. Yes.
Over to you, Advocate Nicole, for the closing.
Thank you. And it is indeed a privilege and an honor for me to thank Judge Keithley. Ahmed has asked me to repeat my introduction as it was bad. For the record, let me say that I am sitting in Judge Keithley's chambers, which was her chambers before. But before her elevation to the bench, Judge Keithley ran a successful practice at the Johannesburg Bar. In line with her varied practice, she has presided over and written judgments on various aspects of the law. The systematic and practical nature of her thinking is powerfully expressed in her judgments. Hers is a methodical approach which is rooted in her time as a professor at the University of Cape Town, where she lectured in human rights law, international human rights law, property, succession, and international law, and she was a member of the editorial board of the South African Journal of Human Rights and also the director for the Center of Applied Legal Studies. Her judgments are characterized by her extensive analysis, which is buttressed by her practical experience as a senior state advocate in the Asset Forfeiture Unit and her time as Deputy Director of Public Prosecutions. I would personally encourage practitioners to read her judgment on interim interdicts, which is better than any textbook. Judge Keithley is well known as an author of various articles relating to family law, and in addition, she's definitely known for her feisty nature and this approach. Judge Keithley, your slides today have simplified case management, and we thank you for your time.
Oh, it's an absolute pleasure, and those were such kind words, Nicole. Thank you very, very much. I'm really very, very grateful. Thank you. And it's been such a pleasure and an honor for me to talk to you. I'm very pleased Judge Victor was not able to, although I must say as the acting Deputy Judge President, she would have been the more direct line for all of these issues. But I will take them up with the JP and with the ADJP. And hopefully some of them at least can be dealt with more quickly than not. So yeah, but I've enjoyed it, and thank you so much, and thank you for your robust engagement. You know, I think that we have a very good relationship with the profession, largely led by our JP and both of our DJPs, and so long may that continue. And I think I speak for all of my colleagues when I say our doors are always open to assist with training or whatever you need to do. We feel that it's and I personally feel it's a really important part of my job. And it's been an absolute pleasure for me to be with you this afternoon. Thank you very much. Is court adjourned? No, court adjourned. I'm going to call it. Court is adjourned. Go well, everybody. Keep safe. Good luck with keeping your practices going. And please look after yourselves. Goodbye.